today, among the many activist roles Eddie Tabash has done, he is the chair of our legal committee of the Americans United for Separation of Church and State. But he's also chair of the board of our Center for Inquiry Transnational. He's known as a First Amendment expert in all sorts of First Amendment issues, and particularly in talking about separation of church and state, the importance of it, and why we have to have full equal rights for everyone regarding church-state separation. So without further ado, please a warm welcome for Eddie Tabash. It's on?
It's almost on. I want to thank all of you for coming today. Today's presentation will deal with what would happen if there is a shift one way or another in the composition of the Supreme Court. Because we are a 501c3 organization, and because, unlike many religious right-wing organizations, we don't violate the law, we will not endorse or oppose specific candidates by name in this presentation. But for anyone who is concerned with the future of the United States Supreme Court, which means whether or not we have separation of church and state, the election in 3 weeks, both for the White House and the U.S. Senate, is crucial, because we stand on the threshold of two possible futures. One future is one in which we continue on our march toward becoming a modern secular democracy. The other future, which would depend on a shift of just 2 votes on the court, would have us slink back into being a virtual theocracy, which America has never been. And this all depends on who wins the election and who makes the next 2 appointments to the United States Supreme Court. And so, because the President nominates for the Supreme Court, and the Senate has the power to accept or reject the nomination, elections to the White House and to the U.S. Senate are crucial in determining who gets confirmed to the Supreme Court and who gets rejected. What I am recommending, again without announcing support or opposition to named candidates, what I am recommending is that those of us who care about secular government, whether you are an atheist like me or a religious believer, but one who doesn't want to impose your religion on others, is that when it comes to the United States Senate and the presidency, you vote primarily based upon which candidate will most support government that must be neutral in matters of religion. I will define separation of church and state to mean that no branch of government can favor believers or non-believers, that no branch of government can favor you depending on what viewpoint you have on matters of religion, and that believers and non-believers were intentionally designed by the framers to be equal before the law. I'm going to take you through essentially much of what is in your handout. And the reason I'm doing this is I want all of you equipped with the arguments to show that even though the historical record is sparse as to the actual formation of the First Amendment, that as sparse as it is remarkable. It is remarkable how such a relatively short and flimsy historical record shines through in still demonstrating that the framers believed that believers and non-believers should be equal before the law. And to do this, I'm going to give you a dominant theme, the thread of which goes through this entire area of church-state separation. The framers wanted, particularly the principal architect of the First Amendment, James Madison, and his main influence, Thomas Jefferson. They wanted an America in which the rights of conscience of each human being is protected regardless of where those rights of conscience lead. So whether you were a believer or non-believer, the framers of the First Amendment specifically intended that the rights of conscience of each individual to determine their own position on how the universe is put together, whether it results in accepting or rejecting any concept of God, that those rights of conscience be unfettered by government coercion. And so if you view the founders as trying to protect the equal rights of conscience of everybody and to make sure that there is an uninhibited legal liberty enjoyed by every person in the new nation then of the United States, an unbounded liberty to choose your own viewpoint on matters of religion and not suffer any adverse legal consequences regardless of what those personal beliefs are, then you will understand what the founders had in mind. But if you keep this thread in your mind of protecting the rights of conscience, then everything falls into place. And it is an exceptionally majestic and wonderful idea, particularly for the late 18th century, that we had people of such great vision that their uppermost concern was not to promote a particular viewpoint on matters of religion, but to promote the absolute liberty of anyone to choose any possible viewpoint. When the 55 authors of the original Constitution gathered in 1787, they refused to pray for guidance, even when their deliberations were stymied. The Constitution contains no mention of any God. The only mention of religion in the original Constitution is a negative one. Article 6, Clause 3 prohibits any religious test for public office. When debating whether or not the Constitution should be ratified, future Supreme Court Justice James Iredell said that it would be fine if we allow pagans and those who have no religion at all to be elected to office. 4 years before drafting the initial form of the First Amendment, James Madison opposed all religious assessments for the benefit of clergy, but even more in his home state of Virginia, in his memorial and remonstrance against religious assessments. 4 years before even beginning to work on the First Amendment, Madison wrote, "During 15 centuries has the legal establishment of Christianity been on trial. What have been its fruits? More or less in all places, pride and indolence in the clergy, ignorance and servility in the laity, in both superstition, bigotry, and persecution." What this tells you is that anyone who says our First Amendment was prepared by Madison to support a Christian nation is telling you something false. This is irrefutable proof that Madison believed that government established on Christianity is dangerous. It also tells you that he has nothing against Christians who hold various beliefs, but he does not want them to use government as a vehicle for imposing their religion on anyone else. In 1786, Madison secured the passage through the Virginia legislature of his and Jefferson's Virginia Statute for Religious Freedom, which shielded minority viewpoints on religion against tyranny of the majority. The greatest influence on Madison in matters of church-state separation, Thomas Jefferson, wrote much later in 1821 in his autobiography how happy he was that the effort to dilute the statute to protect only Christians was defeated. Jefferson was delighted that the bill protected everyone, including, in Jefferson's words, the infidel of every denomination. So if Madison and Jefferson pushed a bill through the Virginia legislature to protect the infidel of every denomination, they were preparing to support on a nationwide basis the equal rights of conscience of everyone, believer or non-believer. Madison wrote to Jefferson after the bill successfully passed that this country has extinguished forever the ambitious hope of making laws that restrict the human mind. Once again, you see this magnificent dominant theme, protecting the rights of conscience of everyone. Madison and Jefferson were not believers in any kind of Christian doctrine. In October of 1819, Jefferson wrote to William Short and rejected all the supernatural claims about Jesus, including the Immaculate Conception, miraculous powers, resurrection, the Trinity, original sin, and atonement. Again, this doesn't mean that Jefferson wanted to see Christians persecuted. He wanted to make sure that no one be permitted to harness the power of government to impose a religious viewpoint on anyone. In April of 1823, Jefferson, the retired third president of the United States, wrote to John Adams, the second president of the United States, expressing his rejection of supernatural claims about Jesus. And he said, "And the day will come when the mystical generation of Jesus, by the Supreme Being as his Father in the womb of a virgin, will be classed with the fable of the generation of Minerva in the brain of Jupiter." Once again, no religious dogma was accepted by Jefferson or Madison, so they couldn't have possibly contemplated a Christian country, but they did contemplate a nation in which Christians, atheists, and everyone else would be free to believe what they wanted to believe. In 1787, Jefferson published his Notes on Virginia. And in his note number 17, we see the full flowering of what he really believed. Now understand this, nobody doubts historically that there was any greater influence on Madison, who actually wrote the First Amendment, than Thomas Jefferson. So we can deem as interchangeable their views. And this says it all. Jefferson wrote, "The legitimate powers of government extend to such acts only as are injurious to others, but it does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg." What is Jefferson saying here? Whether you believe in no God, 20 gods, one God, any God, you are to be left alone because you're not harming anyone. That intellectual dispute, verbal written dispute about the nature of reality doesn't really hurt anyone. And in a nation that protects the rights of conscience, everyone should be free to express those views. In an 1813 letter to Alexander von Humboldt, Jefferson wrote, "History, I believe, furnishes no example of a priest-ridden people maintaining a free civil government." What he was saying is there is no problem in a nation with religious people. There's a problem in a nation where religious people get to control the government and the clergy has official legal power. In writing to Horatio Spafford, Jefferson wrote, "In every country and every age, the priests," meaning members of the clergy, "have been hostile to liberty. They are always in alliance with the despot." Once again, Jefferson and Madison are saying, believe what you want, but don't commandeer the police power of the state to impose that view on anyone else. In August of 1787, Jefferson wrote a letter to his nephew Peter Carr, and he said, "Fix reason firmly in her seat, and call to her tribunal every fact, every opinion. Question with boldness even the existence of a God, because if there be one, such a God must more approve of the homage of reason than that of blindfolded fear." Jefferson was saying all Americans should be free to believe what they want, and that belief and the search for the truth as you see fit should be unfettered, and government should leave you alone regardless of what you ultimately decide. And then writing in Federalist number 52, Madison, a year before beginning work on the First Amendment, said that public office should be open to merit of every description without regard to any particular profession of faith. So to Madison, it didn't matter what you believed, you should have an equal chance of serving in government. That is not the words of someone who wanted a Christian nation. In October of 1788, very tellingly, Madison wrote to Jefferson and expressed concern that the people would deny infidels the right to hold office or restrict the rights of conscience. This shows you the principal architect of the First Amendment was absolutely devoted to protecting the equal rights of the non-believer, and in an overarching fashion, in keeping with the theme that I mentioned, he was devoted to making sure the rights of conscience are respected. So what we had in the late 18th century is this tremendous insight of enlightenment by the founders that the rights of conscience of each individual must be protected above all, regardless of where that individual ends up on the theological scale. In June of 1789, Madison introduced into the First Congress a proposed amendment to later become the First Amendment, preventing government from abridging the civil rights of anyone because of belief or worship, preventing infringement upon the full and equal rights of conscience. Again, to keep this unbroken theme, and this is so amazing given how sparse the record is, we have even a further example of how the founders and the members of the First Congress were devoted to protecting the rights of conscience for everyone. Representative Daniel Carroll, who was one of the signers of the original Constitution, said in the debate, "The rights of conscience are in their nature of such peculiar delicacy, they will little bear even the most gentle touch of government hand." What is he saying? In order for every human being to make their own choices on whether to believe or disbelieve in any doctrine of religion, government has to leave people alone and cannot favor one over the others. This is such a powerful historical refutation to the religious right claim that the Bill of Rights was designed to still favor believers over non-believers, but yet there is even more. The religious right of today and their justices on the Supreme Court, as led by the now deceased Justice Scalia, took the position that government can favor belief over non-belief, but said government must not choose one religion over others, which means government only has to be neutral among religions, but can side with religion collectively against non-believers. Scalia later modified that, as I will show to you in a few moments, in a very scary way, saying that not only can government disregard atheists, government can disregard polytheists and those who believe in unconcerned deities. So according to Scalia, deists and Buddhists and Hindus, as well as atheists, are outside the protective cover of the First Amendment. But the strongest refutation of the religious right claim that government can only be forced to be neutral among religions, but can side with all religions against non-belief, came on September 3rd of 1789, when the Senate rejected two proposed wordings that would have done just that. If, in fact, the First Amendment, the Establishment Clause, only prevents government from favoring one religion over others, then one of these two wordings would have been accepted. Their rejection and never being brought back is powerful historical proof that we are right, that the founders intended government to be neutral, and that neutrality extended to protecting non-believers. One proposed wording that was rejected and never brought back was no law establishing one religious sect or society in preference to any other. The second rejected wording was no law establishing any particular denomination or religion in preference to any other. Any one of these two wordings would have done what the religious right claims is now the law, but they were rejected. And then finally, when Madison chaired and oversaw the conference committee between the House and Senate, the final wording was so broad: no law respecting an establishment of religion. This doesn't just mean no law that favors one religion over another. That was rejected. A law can't even show respect to any establishment of religion. When you consider all the options that the Congress had and rejected, and the final wording they adopted, it's clear they wanted everyone to be equal before the law. As Jefferson said in an 1802 letter to the Danbury Baptists, the Establishment Clause built a wall of separation between church and state. And so when we look at the work of Madison and Jefferson, their subsequent opinions can reflect back on what they were thinking when the First Amendment was being crafted by Madison with Jefferson's influence. They didn't change their views. Madison was so concerned about the accumulation of power by religious institutions, he even had misgivings about religious organizations holding property. Jefferson, as president, refused to issue Thanksgiving proclamations because he felt they were religious exercises. Madison, writing in the detached memoranda in 1817 after leaving the White House, opposed tax exemptions for property already owned by religious institutions. None of this would even be acceptable in the most socially liberal politician of today. But with the rise of the religious right in the 1980 elections, we saw an attempt of the new religious right to impose religion by force of law on all Americans. Now, Center for Inquiry, Americans United, are both nonpartisan organizations. So we're not taking sides here. In fact, if somebody wants to be objective, you can say that conservatives are the wrong people to embrace the religious right, because if conservatives believe in limited government, they don't want a religious tyranny that intrudes itself into the most intimate areas of our private lives. And so when I recount what the religious right has been doing the past 36 years, it is not in a partisan fashion, but a factual reporting of what has gone on. In March of 1982, President Reagan, addressing the Alabama legislature, said, "Sometimes I can't help but feel that the First Amendment is being turned on its head. It was written to protect the people of this country, not to shield them from religious values, but to protect religious values from government tyranny." Well, if we can't be shielded from religious values, how far can government go in imposing religion on us? Reagan didn't think that through. Also, he said in his re-election year in 1984, "America needs God more than God needs America. If we ever forget that we are one nation under God, we will be a nation gone under." But what does that actually mean? To what extent can then a person stand up and say, "I reject all concepts of God," and still be an equal American? In 2004, the Texas Republican Party reaffirmed the United States as a Christian nation, which, as I've just demonstrated, is false, calls church-state separation a myth, and calls for abstinence only instead of sex education. While meeting with the Pope in June of 2004, seeking re-election, Bush asked the Vatican to push American bishops to be more aggressive in religious issues like abortion and in support of same-sex marriage ban in a constitutional amendment. In July of 2004, in his re-election year, Bush said, "In Amish country in Pennsylvania, I trust that God speaks through me. Without that, I couldn't do my job." I submit that even if you are a religious person, a very religious person, you would be uncomfortable with the commander-in-chief who claims that God is speaking through them because you want to know which God it is. It might be a God other than the one you believe in. This is why Church-state separation is the most wonderful opportunity for believers and non-believers to work together to implement the ideals of the framers to preserve equal rights for everyone. Both believers and non-believers benefit from a government that is neutral in matters of religion and does not take sides. Again, calling upon conservatives to come back to a consistent view of limited government. How can they support the religious right? If the religious right prevails by a takeover of the Supreme Court, government will be able to intrude itself into all areas of birth, life, death, sex, health, marriage, medicine, and the role of the family. How do we have limited government? Also, not only would abortion rights be in jeopardy if we had a religious right takeover, so would even access to birth control. In 1965, in Griswold versus Connecticut, the United States Supreme Court struck down a Connecticut law, Connecticut, believe it or not Alabama, that prohibited even married couples from using contraception. In 1972, in Eisenstadt versus Baird, the Supreme Court struck down a Massachusetts law, that barred unmarried people from using contraception. The religious right believes that these cases were wrongly decided. How can they be for limited government if they want the state to even be able to ban birth control among consenting adults? We're not even talking about abortion. Public education would also be in jeopardy. One of the true founders of the religious right, Jerry Falwell, wrote in his book, America Can Be Saved, "I hope I live to see the day when, as in the early days of our country, we won't have any more public schools. The churches will have taken them over and Christians will be running them." Also, when President Bush in May of 2001 stopped stem cell research, we fell behind in terms of a true scientific effort to cure many diseases and illnesses. Even former Republican Senator from Missouri, John Danforth, said that this is using religious doctrine to punish people who need medical care. Again, a shift of just 2 votes on the United States Supreme Court, and we lose the 2 most important precedents for gay rights. In 2003, by 6-3 majority, the Supreme Court said that the states could no longer punish persons of the same gender who have sex with each other. Up until then, it was legal to throw gay people in jail for just that. With a shift of 2 votes on the Supreme Court, that ruling could be nullified and the states could punish, once again, gay people who do nothing more than love others of the same gender. We finally succeeded once again in having the Alabama Judicial Council suspend Roy Moore as Chief Justice of that state. But it took a long time to do so. What did he do this time? Notwithstanding the Supreme Court's decision in the same-sex marriage case, Moore unconstitutionally told all the lower court judges in Alabama they could not issue marriage licenses for same-sex couples, openly violating the obligation of all judges to abide by a ruling of the United States Supreme Court. Pat Robertson has had the single most influence of any religious right leader in the appointment of Supreme Court justices when there were sympathetic administrations. In the administrations of Reagan, Bush, and Bush Sr., he had the ear of the president unlike anyone else. And this is what he said back in 1990. Many involved with Hitler were Satanists. Many were homosexual. The 2 things seemed to go together. We never want someone with that attitude to be whispering in the ear of the president about who to put on the Supreme Court. Before Roy Moore was originally removed as Chief Judge, of the Alabama Supreme Court because of the Ten Commandments display in the lobby of the court. He wrote a concurring opinion denying a lesbian mother the right of custody of a child. And he said, the state carries the power of the sword, that is, the power to prohibit such conduct with physical penalties and even execution. It must use that power to prevent the subversion of children toward this lifestyle. Well, I submit that even people who support capital punishment in certain circumstances weren't thinking of executing people just for being gay. Why is the Chief Justice of any state Supreme Court using execution in the same category as he condemns the gay community? This is very, very serious. Also, with abstinence-only sex education, we not only violate church-state separation, we violate science itself. The Washington Post reported 12 years ago that many young people in federally funded abstinence-only programs have been taught that abortion leads to sterility and suicide, and that half the gay male teens in the United States test positive for HIV. They also said that abstinence only, funded by the federal government, teaches that merely touching a person's private parts can lead to pregnancy. If that were true, a certain presidential candidate would have more than 5 children. So we have to be very, very concerned about that. The faith-based initiative has been, for the past 15 years, a very serious church-state violation, where government gives grants to openly religious institutions for social welfare functions. This is something that will only be stopped by a Supreme Court that says this is an unconstitutional violation of separation of church and state. Curiously, we need a president who, even if that president continues the practice, will put people on the Supreme Court to declare it unconstitutional. Now, the chilling words of Justice Scalia make it absolutely crucial that a church-state separation president appoint and a church-state separation Senate confirm his successor. In the 2005 case of McCreary County versus ACLU, Scalia, in what was thankfully still a minority dissent, wrote, "It is entirely clear from our nation's historical practices that the Establishment Clause permits the disregard of polytheists and believers in unconcerned deities, just as it permits the disregard of devout atheists." Well, if I'm a devout atheist or I believe in a religion that's a polytheist, how am I protected by my Constitution? What is Scalia saying? And even more chillingly, Clarence Thomas on the Supreme Court believes that the Establishment Clause is the only portion of the Bill of Rights that doesn't apply to the states, and therefore that each and every state is constitutionally free to establish their own official religion. Now, what kind of horrendous chaos will that lead to? In the 2012 election, candidate Newt Gingrich, who has clearly been guilty of adultery, was saying that we cannot trust the presidency to someone who doesn't pray. In this election cycle, Ted Cruz also took the position that you cannot be trusted to hold the office of President of the United States unless you get down on your knees and pray. So if people who believe that there is a theological foundation to being a good person assume the White House, they cannot possibly regard those of us who reject all concepts of God as being equal citizens. In May of 2014, the Supreme Court in town of Galloway versus New York actually upheld the right of local town councils to have even exclusively Christian clergy presenting prayer invocation before the meetings. In June of 14, in the case of Burwell versus Hobby Lobby, the United States Supreme Court, by a 5-4 split decision, said that even if you are an employer who is running a secular business, but if you have a personal aversion to contraception, you can legally opt out of the Affordable Care provision requiring you to provide insurance coverage to your employees that also cover contraception. And then this year, the Supreme Court deadlocked in Zubik versus Burwell, where religious claimants were insisting that even though the Affordable Care Act says if you're a religious institution and you have doctrinal opposition to contraception, all you have to do is sign a paper so that we, the federal government, can help the employee find coverage elsewhere. They claimed that even that makes them participate in the ultimate acquisition of contraceptive coverage for their employees and didn't want to sign that. And the best the Supreme Court could do was to deadlock. Also, former presidential candidate and former Arkansas Governor Mike Huckabee has called upon everyone to reject the Supreme Court ruling on same-sex marriage because, in his words, the Supreme Court is not the supreme being. We have had instances around the country of town councils trying to reject atheists from giving the invocation. Now, in June of 14, the Pew Research Center issued a finding that 65% of Americans still believe the Bible to be the Word of God. Well, they have a right to hold that belief, but we can never have a Supreme Court that allows them to use that belief as something to impose on all of us through force of law. The state of Texas is still pushing for textbooks that will emphasize the influence of Moses, Thomas Aquinas, and John Calvin on the founding of America, ignoring Thomas Jefferson and James Madison. This is a distortion of history, in addition to being a violation of church-state separation coming from a branch of government. In August of 14 in Indiana, a state trooper was pulling people over for alleged traffic violations, but merely to give them directions to his church so they could be saved. The ACLU represented some of the victims of this, and only in April of this year was the officer fired. Also, 2 years ago, the Air Force refused to allow an atheist to re-enlist because he wouldn't sign an oath that says, "So help me God," and they eventually relented when there was pressure brought upon them. The governor of Kentucky recently told pastors to break the law by openly endorsing candidates for political office. The police chief of Bridgeport, Connecticut, of all places, wants the citizenry to fight crime through prayer. And the governor of Oklahoma recently urged people to pray for the oil industry. I think even if one believes in God, they should realize the oil industry does not need prayers. There is also in Ohio a measure that would require that religious alternatives to evolution be taught in the public schools. Also in 2015, 53 abortion clinics closed in the United States. Before Justice O'Connor retired from the Supreme Court and was replaced by Samuel Alito, her last words to her colleagues were in a concurring opinion when she wrote, "At a time when we see around the world the violent consequences of the assumption of religious authority by government, Americans may count themselves fortunate." And then she finished by saying, "Those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly?" As we can see, the United States Supreme Court and its composition is the single most significant determining factor in what the laws of the land are. 56 years ago, while running for president, John F. Kennedy said to a gathering of Protestant ministers in Houston, "I believe in an America in which the separation of church and state is absolute." Now, more than ever, we have to make sure that the vision he had 56 years ago remains alive and well today, and we have to all work toward making sure that we have an America where the separation of church and state is absolute. Thank you. Okay, questions from, yes.
So if the Senate remains in Republican control, and do you think that they will hold off approving a Supreme Court justice for the next 4 years?
If the Senate attempts to do that, I think there would be an outcry, because the argument against granting hearings and a vote on President Obama's appointment of Judge Merrick Garland was that the winner of this election should be the one to replace Scalia. For them to now say, we didn't mean that, would be terrible. What I do think is this: if there is a president and a Senate of different parties, if there is a church-state separationist president and a religious right Senate, that president will have to compromise somewhat on the candidate. But certainly, I don't believe that the United States Senate could prevent the next president for the entire presidential term from filling Supreme Court vacancies. Now, I have a theory, which is only my theory, and I can't attribute to my organizations, neither Center for Inquiry nor Americans United, because I don't yet have backup. But my theory is that if the Senate refuses to act upon a presidential nominee for the Supreme Court, I don't just mean if they vote to reject, if they refuse to act at all on the president's nominee, they are in dereliction of their constitutionally mandated duty of advising and consenting, and that therefore by default the president's nominee gets confirmed. So far, people in the Justice Department that I've spoke to thinks it's a great idea, but they're not yet ready to run with it. At least they weren't with respect to Judge Garland. My communication with Judge Garland's staff brought a nice response from Judge Garland saying, "Thank you, but this is uncharted territory." So I really think that I'm actually right on this, but there is no legal precedent. The other problem is, with a 4-4 split on the Supreme Court right now, it would be the Supreme Court itself that would decide whether or not the president automatically gets their nominee on the court if the Senate refuses to act. Yes, more questions? Any? Yes, please.
I think it's a mistake to think of the Republicans as conservatives. They're authoritarians. They long ceased being conservative back probably in the 60s, early 70s. And now it seems that if you look at their policies and positions on things strictly as a matter of how an authoritarian would behave, then everything they do is consistent.
Well, whatever it is, since I'm representing two nonpartisan organizations, all I can say is that if you are a conservative, then you should reject the religious right, because the religious right represents authoritarianism. And whether that's happening or not, we don't yet know. But certainly the notion of intruding the police power of the state into the intimate areas of the private bedroom would not be consistent with anything other than the worst form of Big Brother government.
I have a question about state issues. A lot of states, as I understand, actually have tougher constitutions against any kind of religion meddling with government, with state government, particularly in funding. And I wondered if you had any feeling on that, should there be any change in the Supreme Court that might affect...
This is a very good question. It's about the Blaine amendments, in which state constitutions have more specific provisions than even the federal constitution in denying state aid to religion. The problem with that is state legislatures are more eager to impose religion than even Congress in various states. So once the Supreme Court would nullify church-state separation, we would have to argue under those state amendments. But there's nothing to prevent the legislature and the people from repealing those state amendments. See, right now, I would argue in a state that favors the religious right, you still can't aid religion because you have this amendment. Forgetting the federal constitution, you have your own state constitutional amendment. Well, what if religious right sympathizing states began repealing those amendments? See, it's very precarious on all these issues for us to have the scope of liberty vary from state to state. That's why we need a national standard. We need a Supreme Court that mandates government neutrality and the equality of believer and non-believer across the board for every state and territory of the United States. To have a crazy patchwork quilt where in one state you lose your legal freedoms if you don't affirm belief in God, in another state you don't, would make it unworkable. To have an America in which one state is a modern secular democracy, the other is a theocracy, would be ridiculous. So that, you see, the thing is, once the Supreme Court says government can now favor belief over non-belief, where does that end? How far does that go? To what extent can government disfavor the non-believer? See, I don't want to find out. I don't know how far that's going to go. That's the danger that we're dealing with. Now, while we cannot endorse or oppose candidates for political office, we can weigh in on Supreme Court justices. 501c3 nonprofits can definitely support or oppose nominees to the Supreme Court. So organizationally, we can even suggest we can't support or oppose candidates for elective office, but we can certainly support or oppose candidates for the Supreme Court. And so the moment that happens, and so there's nothing barring a 501c3 from saying we should put this person on the Supreme Court and not that person. So we do have liberty to that extent. We can also oppose or support ballot initiatives. You know,
speaking of that, are there any ballot measures on the California?
Nothing that pertain to this.
Pertaining to church-state separation?
Nothing pertain to church-state separation. There are in other states. Also, again, it's not an issue in California because either of the two top candidates would be church-state separationists for the Senate. But in other states, we don't really want to. Yes, we could deal with precariously a situation where there's a church-state separation president and a religious right Senate. We'd like not to have to do that. And so Senate races are crucial. See, now I know that many people have views, very strong views, on all sorts of issues, the entire gamut of issues in the political realm. Now, again, I have no coercive power. I'm just suggesting that given the dangerous balance on the Supreme Court today, when it comes to a presidential election and a U.S. Senate election, that those of us who want secular government, let that be the top priority in the candidate that we choose.
Any other questions?
Okay, I guess that, well, thank you everybody for
Okay.
attending.